matter because, as plaintiff admits in her papers, in order to prevail on her partial summary judgment motion, she has to actually prove the breach of contract claim. And I know that she relies solely on the Trenton case, but in the Trenton case, it expressly says there is no dispute as to contract formation. And in fact, there is no dispute as to performance either. And so in that case, the submission of purchase order or invoices and the showing of not paying in that particular case allows that party to get into entitled to summary judgment. But that's not the case here. And in fact, there's no evidence of the terms of the contracts. They simply put forth the purchase order and say, this is the contract. There's no evidence as to a meeting of the minds of the formation of the contract because the acknowledgements don't actually match the purchase orders that they submitted. And on top of that, there's evidence that we have submitted by way of email showing that the parties weren't agreeing as to the actual terms of the underlying contract. So we have disputed that she's met the burden to prove A, the formation of the contract, and B, the performance of the contract. And in order to get to her breach of contract claim, she has to establish that as her burden before I even get to the issue of a material fact. But with that said, we have identified material facts that make that disputes. There's multiple emails going back and forth between the ISC representative, Mark Kavanaugh, and the abacus representative, Molly Max, where the parties are discussing the terms, but there is no actual mutual agreement as to the terms. And that's actually evolved as the relationship goes forward, because there's questions as to why are you sending these products when we agreed that they wouldn't be sent until a specific date or until we asked you to send them. So clearly the plaintiff did not meet their burden initially to prove a valid enforceable contract. The submission of the purchase orders and the invoices are not sufficient to meet that burden, especially in light of the fact that Abacus's own terms and conditions say that the acknowledgement by itself cannot in and of itself create a contract without some additional agreement. And no such agreement was presented. There is no performance. There's no evidence of what actually was presented or what actually was shipped other than the invoices. And then whether or not that actually conformed to the actual terms of the contract, which we dispute that it did, because we had products that were not supposed to be shipped until October per the actual purchase orders and the acknowledgements themselves, and were actually shipped in February. So there is sufficient evidence that showed there's a triable issue of fact. As to the statement of the accuracies of the invoices, the requests for admissions do not admit that those purchase orders are valid or that the invoices are valid. What they say is that the documents themselves are valid, but dispute as to the amounts that are owed under there. And if you look at the actual full answer to the request for admission that are actually submitted with the motion, it'll show that it is disputed. It's not admitted within that document. So there is no actual burden on ISC at this point to produce material disputes of evidence, but we've shown that the terms of the contract are disputed, the performance of the contract is disputed. And as a result of that, we also identified that there is a dispute as to the actual amount owed. In fact, because we submit evidence by way of Galen Green's declaration that say that we've actually paid a substantial portion of those invoices. So based on that, I don't believe their motion is proper. I think there are procedural defects, substantive defects, and that the motion should be denied in its entirety.
Thank you, Ms. Veronica.
Yes, thank you. So I guess to respond to Ms. Rister, it's sort of twofold as well. On the procedural issue, again, we're not trying to improperly sever two claims within a single cause of action, although the Texas Supreme Court in Chase v. Manhattan has indicated that summary judgment may be granted on separate issues within a single cause of action. Nevertheless, if you look at the pleadings, you look at our motion and our reply to the response, we've indicated that we really have two breach of contract claims. We have a breach of contract claim on the invoices and whether they're owed and whether they were paid. And we have a breach of contract claim over whether contracts were formed between the purchase orders and the acknowledgements, what the terms of those were, if the court determines that there actually was a contract, and whether the $1.4 million that are subject to that, which plaintiff is arguing is non-cancelable, non-returnable, is a separate breach of contract claim. Plaintiff, the issue before the court on the motion is whether there's a breach of contract for failure to pay the 8 invoices totaling $327,000. Even if you exclude the acknowledgments and you just look at the purchase orders are net 30, the invoices are net 30. Defendant has indicated that those invoices were submitted to it, that the total of those invoices on on those documents are the actual total. Yes, they dispute that there's an issue over whether the $327,000 is owed. And plaintiff's position is that we met our burden. We met our burden by demonstrating that the invoices were submitted, that they're due and owing, and that they have not been paid. The burden then shifts to defendant to indicate why the $327,000 is not owed, because they've admitted that there's invoices, they've admitted that they're not paid. So the only question for them to answer in terms of raising a genuine issue of material fact is whether the $327,000 owed, and there's no indication of that. Ms. Rister refers to Mr. Galen's affidavit indicating that they paid $172,000 against the invoices, but those are not against the invoices that are at issue in this motion. There's been a relationship between the parties since mid to July to September of 2019, and there was transactions that arose between those POs and the acknowledgments that are at issue on a separate breach of contract claim, where there was deliveries, invoices, and payments made, and that $172,000 went to those invoices, those outstanding invoices. And if you look, they don't list in Mr. Galen's affidavit, he only lists 2 of the 8 outstanding invoices, yet in their admissions, they admit that all 8 invoices were submitted to them. So you can't have an affidavit that contradicts an admission. And there's no indication in the evidence presented by them of which invoices of the 8 outstanding were unpaid. Why, if their argument is that we did not tender performance, why is it that they can't produce any information in a manner that rises to the level of creating a fact issue as to why what part of the $327,000 is at issue? Because they claim in their evidence, on the one hand, $100-something thousand is owed, but the rest of it's not owed. And I can't tell if it's because they're saying the $172,000 was paid against the $300,000 or what it was paid against. Our position, it was paid against the previous invoices that from the prior transactions between the parties. And so I get the point is that there's no indication of why, given they've admitted those invoices were submitted, given the fact that those invoices are not paid, given that our CEO has averred that the amount is due and owing, that why, if there is actually a material fact as to why the $327,000 is not the amount owed here, why they couldn't demonstrate that in their evidence.
Yes, ma'am.
Can I respond real quick? Just for the record, there are a couple of things. I think the law requires us to request that the court rule on the objections on the evidence on the record or before. And I haven't seen anything that says that the court has ruled on those objections to preserve the objections to the evidence that were submitted in support of the opposition. So I just wanted to bring that up to the record. I don't know how the court wants to address those.
Which objections are you talking about, ma'am?
So there are evidentiary objections that were submitted in support of the opposition to in
your response?
Yes, Your Honor.
Okay.
And I would just request that a court rule on those objections. I think that the law requires they have to be ruled on either at the hearing or prior to the hearing.
Well, I apologize for that.
That's okay.
I have not taken a look. Why don't you continue with the response, because I'd like to hear it, but I will take a look at those now.
If I may, to Your Honor, we've addressed those objections in our reply.
Okay, looks like you did a reply on first.
Yes.
And Your Honor, to the extent that plaintiff's counsel is fine with it, I don't have a problem waiving the objection that you didn't rule on it, if we can do that so that you can rule on them as part of the motion in lieu of sitting here and waiting for you to rule on them. But
good, because that's, Ms. Veronica, you have a problem with that?
I don't have a problem with that.
Because usually what I do is briefly skim.
To the extent that plaintiff's counsel is fine with it, I don't have a problem waiving the objection that you didn't rule on it.
Things falling apart on me. Okay. I'll read everything together and obviously rule on those as part of my initial, as my final ruling on the summary judgment.
Okay, thank you, Your Honor.
Thank you.
And then for the record, I will just go back to address a couple of the points. One, on Exhibit 3 from Mr. Green's declaration that's submitted in support of the opposition on page ISC 465, all of the invoices in the transaction report that are subject to this dispute are listed. And then there is also a summary on Exhibit 3 showing the payments that were made and the timeline to do that. So those documents taken together demonstrate that this $172,000 that has been paid. As to the breach of contract claim, kind of procedurally going back, the motion can only address what's in the pleadings, and based on the pleadings themselves, and even to some extent the motion, the pleading has one cause of action for a breach of contract. Paragraph 9 of the complaint of the petition establishes that there's 5 POs totaling $1.7 million. Paragraph 10 says that 327,000 of those were shipped, and then it goes out and says that they're holding $1.4 million worth of products. Paragraph 14 alleges the performance. Paragraph 15 says they breached. It's one cause of action. And then even in the prayer under paragraph 1, it seeks the full amount of the actual damages. So there is no 2 separate causes of action. And in fact, in the motion itself on paragraph 6 in plaintiff's moving papers, she admits that paragraph 6 specifically says that there is one breach of contract cause of action, totaling, as I can quote, plaintiff's breach of contract claim includes actual damages in the amount of $1.7 million, 60,071 cents or something like that. I won't say 176,007 as to damages. And then in the next paragraph, on paragraph 7, they admit that the parties' transactions that form the base of the plaintiff's suits include the issuance and performance of 5 purchase orders and the sale acknowledgement totaling $1.7 million. Again, this admits that they have to, or that it's one single breach of contract cause of action. And then in paragraph 15 of that, of the motion, they talk about how they have the burden to prove each and every element. And I know that they rely on the Trenton case, but as I mentioned earlier, Trenton case expressly says that the partial motion for summary judgment was proper because there was no dispute as to contract, a valid formation of a contract, and there was no dispute as to performance. And as a result, the submission of purchase orders and inventory or invoices were sufficient for purpose of granting motion for summary judgment. I believe that's all unless the court has additional questions. I think the papers kind of speak for themselves. There are plenty of issues of material facts within them, assuming that even the court gives the plaintiff the benefit of meeting their burden, which I do not believe occurred. And based on that, I believe that there is no basis to grant the partial summary judgment. I will note for the record also, there is some disputes as to the attorney's fees. I think that plaintiff's counsel has addressed one of those substantively, the procedural issue as to the expert designation. And I think I'll just stand on the record as to that versus arguing particulars.
Thank you.
May I reply, Your Honor?
Absolutely.
It's my position that the pleading does raise 2 issues. As it relates to breach of contract, the facts make that clear. The contract cause of action, the paragraphs therein make that clear. if it wasn't broken out into two separate paragraphs, that does not necessarily mean that there should not be a summary judgment granted. If the court, if I could replead and put the two in just the two separate sections in a pleading, it nevertheless does not change the facts that there's two claims for breach of contract here on separate sets of facts. And my final point here is that a PO was issued, invoices were, product was delivered against that PO, invoices were submitted, they have not been paid, and the defendant has the product. You can't keep product and not pay for it. And they failed to demonstrate their burden of showing that a real material fact is has arisen over whether the $327,000 is in dispute. And as it relates to the attorney's fees, I'll stand on my pleadings on that. Thank you.
All right. I will read both the motion, the response, and the reply to the response. And it looks like those are all attached. Did you also submit proposed orders?
Yes, Your Honor.
Corrections? Okay. All right. Let's talk about dates then. We can go off the record. I know, Ms. Veronica, this is a time is of the essence type issue, and I will always concur in that. Let me ask you, is this a jury trial or is this a bench trial?
We've agreed on a bench trial, Your Honor.
Oh, good. That will definitely speed things along. Let me